my name is Michaele Turnage Young. I serve as Senior Counsel at the Legal Defense Fund. As background, the Legal Defense Fund is a nonpartisan organization that has fought for equal access to higher education for more than 80 years. LDF has been involved in every race-conscious admissions challenge to ever make it to the Supreme Court. And together with my colleagues, I represent 25 Harvard student and alumni organizations comprised of more than 16,000 Black, White, Latinx, Native, and Asian American students and alumni as amici curiae in the Harvard lawsuit. In both the Harvard case and the UNC case, the petitioner, SFFA, asked the court to change the law to ban the consideration of race in admissions. SFFA also alleges that both Harvard and UNC failed to comply with existing law. So let me briefly discuss existing law. Under 44 years of settled precedent, it is legally permissible for colleges and universities to consider race as one of many factors in admissions. Bear in mind that the Supreme Court held that quotas were impermissible back in 1978. So we're not talking about quotas. What we are talking about is the limited consideration of race as one of 40 factors in the UNC case and one of more than 100 factors in the Harvard case. UNC is the oldest public university in the country. As was the case with earlier challenges to the admissions policies of public universities, SFFA alleges that UNC violates the Equal Protection Clause of the 14th Amendment of the US Constitution by considering race as one of many factors in admissions. Importantly, the Equal Protection Clause of the 14th Amendment applies to state actors like public universities. It does not apply to private actors. The Harvard case is the first challenge to a race-conscious admissions policy involving a private college to reach the Supreme Court. But even though it is a private university, Harvard receives federal funding. So in the lawsuit, SFFA alleges that Harvard's consideration of race as one of many factors in admissions violates Title VI of the Civil Rights Act of 1964, which prohibits federally funded programs from engaging in racial discrimination. Unlike the UNC case, there is also an allegation in the Harvard case that Harvard engaged in intentional discrimination against Asian American applicants. That claim is novel since in earlier admissions challenges, the claim was that the consideration of race in admissions harmed white applicants. In both cases, the petitioner asked in their complaints that the schools be barred from allowing their admissions officers to become aware of the race of any applicant. All of the lower courts issued 100+ page rulings in favor of the schools. In the Harvard case, the court held that Harvard's admissions policy survived strict scrutiny because it was narrowly tailored to achieve the compelling interest in the pursuit of the educational benefits of diversity. In addition, while 8 student and alumni witnesses testified about the importance of diversity, not one witness testified that they had been discriminated against. And even though SFFA analyzed 480 admissions files, 2/3 of which were selected by SFFA, and data from about 150,000 applicants, SFFA did not present even a single admissions file or application that it contended reflected an applicant who would have been admitted absent discrimination. Given this, the court found no evidence of intentional discrimination. The U.S. Court of Appeals for the First Circuit affirmed that decision. In the UNC case, the district court likewise held a long bench trial, then held that UNC's admissions policy passed constitutional muster. The Supreme Court decided to hear the UNC case before the appellate court could weigh in. And of course, as I'm sure most of you know, the Supreme Court heard 5 hours of oral argument on Halloween in 2022. We heard from the oralist and the Solicitor General that it continues to be of the utmost importance to our multiracial democracy that the pathways to leadership in our country be visibly open to people from all corners of our society. A September 2022 nationwide poll found that 87% of respondents agreed that diverse learning environments enrich the college experience for everyone. But unfortunately, while talent is everywhere in our country, opportunity is not. Too many students of color must contend with systemic and interpersonal racism that detrimentally affects their educational opportunities. It is important that colleges and universities continue to be allowed to consider the full context of applicants' experiences, including the way that racism artificially depresses the prospects of many hardworking, talented Black, Latinx, Native, and underserved Asian American students, so that everyone has a fair shot.